Be ready for the dictation. The dictation speed is 120 words per minute. 5 seconds to go. The trial court dismissed the application. However, when the order was challenged before the High Court, the same was set aside and the amendment prayed for by the plaintiffs was allowed subject to payment of costs. Learned counsel for the appellant submitted that in the case in hand, there was a family partition in original suit number 401 of 2003 filed by Srimati Mahadevi, wife and daughter-in-law respectively of defendant, impleading the plaintiffs and the defendants as party. A compromise decree dated 14-10-2004 was first additional civil judge senior division order dated 31-5-2010 passed by the Lok Adalat District Legal Services Authority. Thereafter, respondents number 1 and 2 filed a fresh suit in 2005 seeking partition of the ancestral property, though in the suit pleading was there with reference to the earlier compromise decree. However, for the reasons best known to the plaintiffs, no challenge was made to the same. As a result of the order passed by the High Court, the nature of the suit was changed from partition to declaration, which is impermissible. The written statement was filed in August 2005. Still, no steps taken by the respondents 1 and 2 in that direction. Part of the suit property having been sold, an amendment was carried out in the plant in July 2006 to impede the subsequent purchaser. Even at that stage, this relief was not sought. It was further contended that the relief of declaration of compromise decree being null and void prayed for by way of amendment otherwise also was time barred as the compromise decree was passed on 14-10-2004. The application for amendment was filed on 8-2010. Even the court fee was sought to be affixed at the time of filing of application for amendment. The application filed by respondents number 1 and 2 did not meet the preconditions laid down in order uh, 6 Rule 17 CPC for permitting respondents number 1 and 2 to amend the pleadings at the fag end of the trial. No due diligence was pleaded. All what was stated was that there was oversight on the part of the respondents number 1 and 2. Referring to the parties who were there in the compromise decree, it was argued that some of them are not parties in the suit in question. Hence, otherwise also challenge to the compromise decree may not be maintainable. Inadvertently, the prayer for declaration thereof as null and void could not be made. The court fee also could not be deposited. No fresh evidence is to be led. The case is at the arguments stage. The same can be argued with mere reframing of the issues. It will avoid multiplicity of litigation and ultimately complete justice will be done amongst the parties who are merely praying for partition of the ancestral property. The other side can be compensated with costs as was even done by the High Court. It is a case in which the appellant has been forced into avoidable unnecessary litigation to rush to this court.